glad you were able to come.
I'm glad that this opportunity arose. How's the rest of the campus?
Really, really well. We had over 800 parents register. I don't know that we hit all that for attendance, but we're also simultaneously Zooming some of the sessions.
Right, this one.
Yep. So keep an eye on, it should be something on Zoom so we can see questions.
Yeah. Actually, I'm going to try to monitor that myself. I got my own laptop hooked up along with this, so we'll see how it goes. I'm not great at multitasking. Hopefully I'll catch everything.
And then, yeah, it's also hard to know which ones are going to be the exciting, like that everybody wants to go to. But we also want the Zoom ones that we can record older stuff that with all the different languages. So this is one that we want everybody to see. So even if nobody's on it, that's still on.
No, it's good. That's good.
Yeah. This is a really good for our, for 16 years. It should be 17, but we missed a year. Good luck. Break away.
Thanks. Buenos tardes. Good afternoon, everyone. We'll go ahead and get started. It's about 2:16 on my clock, and I know this is the last session of the day, so I don't want to keep people longer than they would like to stay. So I hope everyone has had a good conference. I understand this is the 16th year of the multilingual conference. This is my first year, so my first experience, but I'm happy to have the opportunity to talk to everyone about the topic today. So my name is Mark Conyer, and I am an acting supervisor in the Special Education Department of the Illinois State Board of Education. I have been with ISBE for just about 15 years now. And during most of that time, I have been one of our state complaints investigators, which is one of our dispute resolution options that we'll be speaking about today. And then just within the past 4 or 5 months, I've been in a temporary role as a supervisor within our department. Prior to coming to ISBE, my background is in school social work. I did school social work for 10 years approximately in Illinois public schools. So this topic, this presentation is about dispute resolution options in special education. I am aware that there's at least one other concurrent session that is addressing special education. I think someone from the Family Resource Center on Disabilities is doing, so make sure that you're in the right session. But this will be about dispute resolution options in special education. Couple of quick notes, and this is really kind of more for anybody who may be participating virtually via Zoom. There will be a couple opportunities during the presentation where I'll stop and ask if there are any questions that people have, and then hopefully we'll also have a little bit of time at the end for questions. But if you are participating virtually in this session, I'll be trying to monitor the chat box. So please enter any questions that you may have in the chat box, and I'll try to address those when we have those dedicated times for questions. I am fortunately not great at multitasking. Many days I'm not great at single tasking even. So if by chance I miss somebody's question on the chat, my contact information is on the slide, the last slide of the PowerPoint. If for any reason I miss a question or you don't have a chance to ask a question, please feel free to use my contact information and get in touch with me following the presentation. So the purpose of today's session is to explain the dispute resolution options that we offer in special education to parents in our state. And I use the term dispute resolution. Sometimes you will also hear people use the term conflict resolution. we tend to use them interchangeably. I kind of prefer dispute resolution to conflict resolution. I think the U.S. Department of Education usually uses the term dispute resolution. But just know, if you hear dispute resolution, conflict resolution, we're talking about the same thing. So the discussion today is going to focus on the options that we offer at the state level, as well as some options that you may have at the local level if you are a parent who has a concern or a potential disagreement with your school district about special education services. Part of that discussion is going to be to discuss what factors you should consider when you're deciding what dispute resolution option may be appropriate for your situation or appropriate for someone that you may be advising or assisting. It's not our job, or it's certainly not what I want to do, is to, advise necessarily or tell you, oh, this is the best option in this situation. But there are some, I think, important questions sometimes that I'll try to lead a discussion about that may be helpful if you're in a dispute, in terms of what's the right way to try to address this particular issue. And then I will also have some additional resources that are related to special education dispute resolution, which I'll also have in this PowerPoint, and hopefully have a little bit of time to discuss as well. So our agenda is, like I said, kind of an overview of the special education dispute resolution options. The first option, local resolution, is just as it sounds. It's something that's offered at the local school district level. It's not something that our agency typically is directly involved in, although certainly when parents contact us, we provide information about that option, or we'll ask if you have considered contacting anyone at the local level to address these concerns. And then the other four options on those on those arrows, I should say, are actually the options that we offer through ISBE. IEP Facilitation, Mediation, Written State Complaints, and Due Process Hearings. And like I said, we'll talk about how to maybe choose the appropriate dispute resolution option for your situation, discuss additional resources, and hopefully have some time for questions and comments. Okay, so the first option that I want to talk about is local resolution. And this is really an informal way for school districts and parents to resolve concerns without directly involving the state agency, the Illinois State Board of Education. So part of our role at ISBE is to provide information to parties that contact us, whether they be parents, whether they be school district representatives, attorneys, advocates, concerned citizens, whoever they may be. And a large portion of the contacts and calls we get are from parents who may have a concern that they don't feel like maybe their child's needs are being met in terms of special education services, or they just have some sort of disagreement with the school district about that. So we will typically, when we receive those types of communications, have a conversation with the parent to try to understand what their concerns are and how we can provide information to help. And one of the things that we will do is, after we gain an understanding of the situation, we will frequently ask, who have you talked to at the school district about this situation? And many times, parents, by the time they've contacted us, have already had some communication with someone at the school district to try to address their concerns. Other times they may not have. They may have seen our phone number or contact information on the website, or in maybe a document that the school district has provided or some other entity has provided. So sometimes we are actually the first contact that a parent will make prior to even contacting someone at the school district. And while that's certainly, there's nothing wrong with that necessarily, they can certainly contact us or even access any of the dispute resolution options that I'm going to talk about. But really, we believe that the first step ideally should be for the parent to try to communicate or connect with someone at the school district. And there's a couple of good reasons for that. And it's not just because it's, we don't want to deal with the situation or assist the parent. It's not that at all. One of the things, though, to be quite honest, is a lot of times if a parent contacts the school district, they may be able to resolve the situation much more quickly than if they access one of our dispute resolution options. And as we talk about those options, I will discuss some of the timelines that are involved with that, and I think that may become more clear why I'm saying that things can often be resolved more quickly at the local level than even going through us. The other benefit to addressing a situation locally is if it's successful, if I'm a parent and I have a concern about my child's special education services, and I contact someone at the school district, we have a conversation, maybe we have a meeting, and we're able to resolve that issue, that is a positive shared experience as a parent that I have now had with the school district. So in the event in the future, we have some other disagreement perhaps, we have that background where we've already, at least once, been able to work collaboratively together and resolve that issue, to solve that problem. So really working together with the folks at the school or the school district level can have some long-term benefits down the road beyond just possibly resolving whatever the current issue or concern is. So when I say local resolution, what exactly does that mean, or what does that look like? Well, it can take a number of different forms, but generally we're talking about, as a parent or someone assisting a parent, having some type of direct communication with either a staff member at the child's school or a staff member at the school district. And like I kind of referenced a minute ago, that communication can be informal, it can be an email, can be a telephone call, maybe a virtual meeting, an in-person meeting. There's a lot of different types of communications that we can use that kind of fall under this umbrella of local resolution. It could include a formal IEP meeting, or it could be something that's discussed even outside of an IEP meeting. Now, obviously, if this resolution involves changing a special education service that the child is receiving, you would have to do that through an IEP meeting or going through the correct process for that. But sometimes there may be some issues that are related to the services or a concern maybe a parent may have with a particular staff member that could be addressed without necessarily getting everybody together for a formal IEP meeting. If you're participating or thinking about local resolution, who should I contact? Who do I discuss this with? Well, probably the first step, it depends on what the issue is, of course, but probably the first step is to start with someone who's a direct service provider for the child. So that could be the child's classroom teacher, special education teacher, a related service provider. So, if your child receives social work services or speech language services, occupational therapy, that type of thing. Those are related service providers. All those folks work directly, either one-on-one, a small group, or a large group situation with the child. So they have the most direct contact with the child, and they may have information about what your concern is, or they may be actually the person that you are concerned about as a parent. So starting with the direct service provider is usually a good first step. Now, what if you've made that attempt to contact the direct service provider and that's not been successful? Or maybe there's a reason that perhaps the relationship between yourself as the parent and the direct service provider, for whatever reason, isn't the greatest, and you think, well, I'd really rather address this issue with somebody else. Kind of the next step would probably be to go to a school administrator, principal, assistant principal, special education case manager, special education coordinator. Sometimes, depending on your building, your special education case manager may not technically be an administrator, but they may be serving in an administrative-like role, or they may be someone who is working with the special education staff and could address concerns that you may have. Then there's also, if you feel like you have tried to address the issue with school administrators and that's not been successful, you could always contact district administrators. We will often, when we get calls and concerns from parents or emails from parents, we will provide contact information a lot of times for the director of special education for the district, because they're a person that a lot of times can assist the schools within the district to resolve concerns that are coming up. District superintendent, school board. So sometimes we use the term go up the chain of command. Okay, so you have your direct service providers, school administrators, district administrators. And you don't have to necessarily go in that type of order when you're trying to address concerns, but it kind of makes sense to do that. Sometimes district administrators, if you contact a special education director or superintendent, especially in a bigger district, they may not be able to get back to you right away, so there might be a little bit of lag time there, which is why a lot of times you can get a quicker resolution if you start with somebody at the school level. Okay, so that's local resolution. Like I said, that is not something that our agency at the State Board of Education is directly involved with, but we will ask those questions and suggest or encourage parents to look at that option, to think about that when they contact us. If that's not successful, or there's a reason why a parent thinks, I just don't think these local resolution efforts are going to get me anywhere, maybe I've tried this before and it's not been successful, then we start talking about the options that we offer at the state level. So the first one I want to talk about is state-sponsored IEP facilitation. This is actually our newest dispute resolution option that we offer at the state level. It is something that we've offered, I want to say, probably for about the last 4 to 5 years. But we did not have that option previous to that period. IEP facilitation is not something that's required for a state to offer under federal special education law. There are many states like Illinois that now offer this system, but it's not a required dispute resolution option for the state to offer. And it is, I would like to tell everyone also, our most underutilized system at the state level. We piloted it in the first year, and then it's gone statewide, like I said, for the last 3 or 4 years. But to be honest, we don't get a whole lot of use or requests related to IEP facilitation, at least in comparison to the other dispute resolution options that I'll talk about. And there's probably a few reasons for that. I suspect, number one, like I said, it is a newer system, so people may not have a history with it or know much about it. I think also there's probably on the district side sometimes a little bit of reluctance to participate in IEP facilitation. They may think, well, we know how to run IEP meetings. We'll talk a little bit about what facilitation looks like. So I think there's been some hesitation for districts and parents to engage in IEP facilitation, but it's potentially a really good process. So I'll talk a little bit about that now. So the purpose of it is to help parents and school districts communicate effectively to develop a mutually acceptable IEP. So the goal of a successful IEP facilitation is we have the IEP meeting, and at the end of that meeting, we have completed an IEP for this child that everyone at the table, the team, is satisfied with. That may not sound like it's a high bar to reach, but if you've ever been in some contentious IEP meetings, you know that's not always easy to achieve. So in some situations, that actually is quite an accomplishment to develop a completed IEP that addresses the child's needs and that everyone is satisfied with. So unlike the other 3 dispute resolution options, IEP facilitation can be a preventative measure. So in other words, there doesn't necessarily have to be a conflict or a dispute or a disagreement in order to request IEP facilitation. A lot of times, that is the reason it's requested. It may be because the parent and the district have had difficulty in the past working collaboratively to develop an IEP. So for this meeting, they decide, let's get an IEP facilitator in to assist us with this process. But it doesn't have to be that way. It doesn't have to be because there's a conflict. It could be if I'm a parent and my child has had an IEP for several years and I just don't feel like the services that he or she has received to this point are really meeting his or her needs. And I think we need to have a better discussion. We need somebody to help us to make sure that we're identifying the correct services and supports for the child. That would be a very appropriate reason to request IEP facilitation and have one of our facilitators come in and assist the team with the process. So that is unique about IEP facilitation in comparison to the other systems that we offer, is that there does not actually have to be a disagreement or conflict in order to address it, in order to request it. So similar to local resolution, it can help improve the relationship between school districts and parents. Again, kind of the same idea that I was talking about with local resolution. If I have a concern with my school district, we sit down, we meet, we're able to resolve it, and we both leave that meeting satisfied. Again, that is a positive shared experience that I now have with the school district, and that gives me a little bit more confidence in that if a situation comes up again where there's a disagreement, well, we resolved it once, maybe we can resolve it again. So that is something, again, at IEP facilitation, you have the IEP team meeting together with the assistance of one extra person, which is the IEP facilitator, and they're trying to help everybody make sure that everybody's communicating effectively, everybody on the team is getting their concerns heard, everybody's getting their input out there on the table, and hopefully at the end of that, we've developed an IEP for that student that is going to meet that child's needs. IEP facilitation, another important point, is voluntary on the part of both the parent and school district. So there is no requirement for anyone to participate in IEP facilitation. If a parent requests that service, our coordinator for IEP facilitation would contact the school district to see whether they want to participate. If the school district says, yes, yeah, we'll try that, then the coordinator would assign one of our facilitators, and then they would go about scheduling the meeting. The district could decline the request. They could say, no, we don't want to do IEP facilitation. They could provide a reason, or they don't have to provide a reason. At that point, that request would be ended. There wouldn't be anything more that the coordinator could do. So that also works the opposite way. If a district requested IEP facilitation, said we've got a meeting coming up with this on this child, and we think it might be helpful to have somebody else in the meeting assisting us. The coordinator would contact the parent in that case because the district made the request. And the parent would have the option to either agree or decline. So IEP facilitation, voluntary process for both parents and districts. So as I said, if you went to IEP facilitation, there would be a neutral facilitator assigned who's not affiliated with the school district. All of our facilitators have been through training in the process. Most of them have some type of special education background. Some of them may not necessarily have a professional special education background, but they may have some training in like techniques of mediation. I'll discuss this when we get to the mediation session, but a lot of our, we have contracted staff that do both IEP facilitation and mediation. Some of them do both of those processes, and because they include some similar types of skills. Important note about the role of the facilitator cannot order either party to take a certain action. So they are not there as the IEP police, so to speak. They are trained in how the IEP process should work in terms of, we talk about the child's present levels of performance, their goals, accommodations and modifications, services, placements. So they understand how the IEP is to be developed, but they're not there as a gotcha to say, oh, school district, you didn't do that right. We got to do this first, or anything like that. They're really there, again, to facilitate the communication between the parties, and like I said, make sure that everybody's positions is heard, and also help to foster some creative solutions if people are having some difficulty. So in terms of the quickness, IEP facilitation is fairly quick. In order to have a meeting, usually the meeting is held within about 4 weeks of the request. Because this is a regular IEP meeting just with the assistance of the impartial facilitator, the district still needs to provide their required notice of the meeting, which is at least 10 days notice in Illinois. Of course, the parties can waive that, but they do have to provide that notice. So there is a little bit of time that's needed to get everybody together and come up with a mutually agreeable date. But typically about 4 weeks is the time period that you're talking about. As I said, a successful facilitated IEP meeting will result in a completed IEP that's mutually agreeable to the parent and district. And you see I provided a link to the request form on our website for facilitated IEP, and you'll also see links to the request forms for the other 3 dispute resolution options as well as we get through those. Okay. Second option that we offer at the state level is state-sponsored mediation, and this is designed to resolve disagreements regarding special education services, placement, related services. It also could be, you could also discuss disagreements about eligibility for services or an evaluation. So the principles of IEP facilitation and mediation are pretty similar, okay? Like I said, a lot of our contractors that we work with that do IEP facilitation also do mediation. They don't all do that, but many do. So like facilitation, in mediation, you're getting a group of people together. There is a disagreement. Like I said, facilitation, there may not be a disagreement as of yet anyway, but in mediation there is some sort of dispute that's the purpose that the parties are meeting to try to resolve that dispute. And the mediator, like a facilitator, doesn't have the authority to tell the district what they have to do. They don't have the authority to tell the parent what they have to do. Again, their purpose is to promote that communication, help with some problem solving, and then help the parties draft an agreement if they reach an agreement. So like IEP facilitation, mediation is voluntary to participate in. Again, if the parent requested mediation, our coordinator would contact the district to see if they wanted to participate, and vice versa. If the district requested the service, our mediation coordinator would contact the parent to see if they wanted to participate. So one difference is mediation is a meeting, can be conducted in person or virtually, but it's not a formal IEP meeting. And typically, there's fewer participants in mediation than IEP facilitation. So in mediation, you may have a group as small as, say, 4 to 5 people, and that's it. You would have the mediator, you have a parent, and maybe someone that's helping the parent that they want to bring along to the meeting, and you may have 2 to 3 representatives of the school district. So if you've ever been to an IEP meeting, depending upon the needs of the student, if you have a student that has some high needs and is receiving a lot of services, those IEP meetings can start numbering in double digits with the number of people that are present. That's not typically going to be the case in mediation. So because of that sometimes makes scheduling of mediation a little bit quicker than IEP facilitation because there's fewer people that you have to coordinate with. So mediation sessions can usually be held within, say, 2 to 4 weeks of the request. 2 weeks is relatively quick, but I know that's not out of the ordinary in terms of having that meeting held. So like facilitation, the mediator is impartial. They are not affiliated with the school district in any way. And they don't have an interest in what the outcome is of the mediation session. But they are there. The goal of mediation is that at the end of that meeting, there is a written agreement that's signed by the parent, as signed by the representative of the school district, that details what is going to be done to resolve the dispute. And that agreement, contract, if you want to call it, is something that is enforceable in court at that point. It does become a legally binding document. Okay, I think I'm going to stop here before going on and talking about the other 2 dispute resolution options that we offer at the state level, and just see if there's any questions from anyone. Yes?
So, is this, okay, I've heard of this, this role that has come to my attention with regards to the IEP where you have an advocate. So is the advocate the same as the mediator? That was just something that I was curious about.
Okay. So the question was about advocates at IEP meetings. Is the advocate the same role as the mediator or the facilitator? No, that's a different role. So usually when in the context of that we use the term, an advocate is typically someone who is assisting, and I don't want to use the term representing because that kind of indicates that maybe they're an attorney, but an advocate is usually directly assisting the parent. So, and they may come to IEP meetings with the parent. They certainly could come to a mediation session with the parent if the parent wanted them to. They may be providing assistance outside of IEP meetings, but that's a different role. They're specifically working in support or directly on behalf of the parent's interest. So the mediator or the facilitator is, like I said, a neutral person. So they're not representing either side. They are there to make sure that everybody that's at the table, though, does get their concerns heard. And certainly there are some situations in which, you know, a parent may request mediation or IEP facilitation because they feel like when they attend an IEP meeting that they don't get their concerns heard, you know, that it's really kind of the staff at the school district that really kind of dictate what the outcome is. So that may be a reason that they request the mediator, but that's a different role than what an advocate plays.
I don't know if my question is really best for another presentation, but I'm just curious because it seems like they do have a voice in the IEP process, and so I was curious, are they supported by the state, or is that a federal position?
advocates, you mean?
Yeah.
That would be something, so a parent would obtain that privately, the services of an advocate. So we don't offer advocacy services per se at the state. There's no, source of federal funding per se for that I'm aware of.
They seem to have a voice in the IEP meetings, I noticed that.
Yes, yeah, and that is usually why parents have enlisted the services of an advocate. They feel, I feel like I'm gonna have a better chance that my child's needs are met if I have a strong voice with me who's experienced, who knows about special education, and is assisting me with the process.
And then I did have another question. With regard to the state-sponsored mediation, so when there's like a small powwow, so to speak, with regard to certain individuals, does that mean that whatever is decided upon or action that then was determined at that meeting, does that go into the IEP at that moment in time?
Great, that's a great question. So the question was, if you have a mediation session and there is an agreement that would potentially affect the student's IEP, does that go into the IEP right then at that mediation session? The way the process should work technically is there should probably be a follow-up IEP meeting after that to, if it's a change in service or whatever it is, document that in the IEP. So a good mediation agreement should really probably spell that out. We agreed to add occupational therapy services to the student's IEP. The team will meet within 3 weeks of this meeting to add those services to the IEP. Okay, you're welcome. Good questions. Anyone else have questions before I move on to the next two options? Okay, I don't see anything in the chat. Okay, so I'm going to do a little visual here. Local resolution, IEP facilitation, mediation. This is the way I think about it. They're different. I've tried to explain the differences, but they kind of all go, to me, in a similar bucket, so to speak, in terms of your dispute resolution options. Now we go to the other side, which is a written state complaint and due process hearings. And I'll talk a little bit about why they're all options, but there's some pretty big distinctions between those options. Okay, so a written state complaint can be filed by anyone that has knowledge of the educational issues concerning a child. And when I say anyone, I mean anyone. This is unique in terms of our dispute resolution options. IEP facilitation, mediation, and due process hearings have to be requested by the parent guardian of the child, or if the parent guardian's has legal representation, and that person is working on behalf of that parent or guardian, they could request it. A state complaint, the majority of our state complaints do come from parents of children who receive services, but it could be filed by anyone. So like I said, we have received state complaints from advocates. We have received state complaints from district employees, former district employees, neighbors who know a family and believe that they may be not getting appropriate services. So that is one of the key differences about state complaints. In order for us to initiate an investigation, the complaint must identify the child, or in some cases, maybe there's multiple children that are involved that the complaint is being filed about, and then the facts that have led to the dispute. So we have to know, for example, we get a complaint that says, my child has an IEP and their needs are not being met. Well, we need some more specific information usually to be able to initiate an investigation. What do you mean by their needs are not being met? Does that mean that the services in their IEP are not being provided? Does that mean that they have some additional services that are not in the IEP that should be being provided? We need to know information like, dates, maybe dates of an IEP meeting that was held, or dates where a service is not being provided. So there does have to be a factual basis behind the complaint in order for us to investigate. This question comes up a fair amount. The complaint does have to be in writing, so we cannot initiate an investigation based just on a verbal complaint, and it does have to be signed by the person or persons who's filing the complaint. So under both our state regulations as well as the federal regulations, we are not allowed to investigate anonymous complaints. The individual filing the complaint does have to identify themselves when they file the complaint. We are time limited in the complaint process, so we can investigate alleged violations of special education rules or regulations that have occurred within the past year from the date that we received the complaint. So the investigations are conducted by ISB staff members. Like I said, that's one role that I've had with the agency for about almost 15 years. We currently have a core of 4 other investigators that pretty much, that's their full-time position. So we do have a timeline to complete the investigation, which is 60 calendar days from the date that we receive the complaint. So that obviously is 2 months. So if you think back about when I talked about IEP facilitation and mediation in terms of how quickly those meetings can be held, 2 to 4 weeks roughly, you're talking about potentially a complaint investigation being twice as long in terms of a period of time. So the other options that I talked about typically are quicker ways to resolve a dispute. So what we would do in a complaint is we would identify the allegations of the complaint. We will request the school district to provide a response to the complaint, which includes documentation that we have requested. The investigator may supplement those documents with interviews. On occasion, we will make on-site visits to school districts to conduct the complaint investigation. And once all those materials are received and reviewed, the investigator will issue a written decision, again within that 60 calendar day timeline, that will describe whether the school district met or complied with the requirements that we were looking at, or whether they did not meet the requirements that we were looking at. If they are found to be in violation on one or more requirements, the district is required to do some sort of corrective action to address that particular issue. And that corrective action is really, there's a range of different things, and it's really based on the individual circumstances of the case. But they could include things like compensatory education services if if we found the student has not received services they should have. It could include things like convening an IEP meeting to add services to the IEP that the student should have received or needs. It also includes things like training to staff in some situations. So there's a number of different things that would be required as part of the complaint investigation. Unlike mediation and facilitation, a complaint is not voluntary. So if a parent files a complaint, the school district can't say, oh, we'd rather not participate in that. We understand that they would rather not participate in that, but that's not an option in terms of the written state complaint. We do not have a formal appeal process for our decisions for the written state complaint. That is a difference from due process, which I'll discuss here in just a minute. Okay. So due process hearings have some similarities to a complaint, but some significant differences as well. So a due process hearing would be requested if a parent, and it's usually a parent, there are a few circumstances in which a school district could actually request a due process hearing. But in the overwhelming majority of cases, it's the parent who will file a due process, in quotes, complaint. And I put that in quotes because that is different from the written state complaint that I just addressed. So a due process hearing looks a lot like going to court against the school district, because there is the hearing officer who presides over the case, who functions a lot like a judge would in a court setting. For a due process hearing, there is typically a pre-hearing conference in which the parties have to show or talk about what evidence that they're going to present at the hearing, what documents, what exhibits are going to be presented. And then at the hearing itself, there is, like I said, presentation of exhibits. There is testimony by witnesses. There is cross-examination of witnesses. So all those things sound a lot like court. So it's a highly formal process. It often involves attorneys and advocates, although it's not required. Parents do not have to enlist an attorney to request a due process hearing. Many believe that if they're going to do that, that's their best opportunity for a resolution in their favor, but it is not required, but they are often present. In most cases, school districts are represented by their attorney at a due process hearing. So one difference from complaints is that due process hearings can address issues going back at least 2 years. As I said, written state complaints can only go back 1 year. Due process hearings, there's a little bit more latitude there in terms of the issues that can be addressed. So the timelines are complicated with the due process hearing. So if a parent requests a due process hearing, by regulation, within 30 days of that request, there is supposed to be an opportunity for the parent and the school district to meet without the hearing officer to try to resolve the issues of that due process complaint. So now we're kind of back to the idea of local resolution, right? That resolution session can be held with the assistance of a mediator, or it can also be held without a mediator. So there's a 30-day resolution period in which the parties have to try to resolve the issue. If they do not resolve the issue, the hearing is supposed to be held within 45 days after the resolution period. However, it is very common in due process hearings for the parties to agree to extend those timelines. And that's in large part because of there's exhibits, getting witnesses. There's a lot of preparation that has to go into a due process hearing. So in a lot of cases, it's extended way beyond the 45-day timeline. There are cases in which due process hearings are pending for months, unfortunately. The good thing, I would call it a good thing, is most of the requests for due process hearing do not eventually end up going to hearing. Most of them do get resolved either through the resolution session, through a mediation agreement, maybe some sort of private settlement agreement between the parties, and sometimes those agreements happen quickly. Sometimes they're months down the line as well. So, like complaints, due process is not voluntary. If a parent requests it and the hearing officer reviews the case and says, yes, this is something that I have authority over, the district has to participate in the due process hearing. The hearing officer can also order the district like a complaint investigator would. The hearing officer will issue a written decision, and that will describe whether the district has violated the student's rights in any way, and if so, that order would also include the remedies that the district would have to take to correct that. Okay. Questions about written state complaints or due process hearings. Yes, ma'am, go ahead.
How does this work with all of the teacher shortages? And some of like the sped teachers are told to cover classes.
That's an interesting question. So the question about is how does all of this work in light of the teacher shortages, special education staff shortages that we know are going on? Well, a lot of, particularly in complaints, and I think this also applies to due process hearings, but particularly in complaints, many of the complaints that we receive are, alleging that a student is not receiving services they're required, and many times that's because there's no staff, right? Somebody's left the position, the district's unable to fill that position. So the bottom line is the requirements of an IEP are the requirements of an IEP, so the district has to find a way to provide the services that a student needs. But logistically, how do you do that if you are pulling staff from different places is definitely an issue. But we are seeing really high numbers in terms of and accessing these dispute resolution options this year. We're headed for a record year with state complaints, due process requests are high, and the staff shortage is a big part of that increase. So, question?
If a parent files a state complaint and then files due process on a separate issue, will they still both go through, or do the state complaints get put on hold? But separate issues, I understand if it's the same issue, the state complaints can kind of put on hold.
Right, right. So the question was, if there's a state complaint and a due process request at the same time, but there are different issues in those cases, how does that work? Would the complaint be on hold? If that was the case, both of those could proceed at the same time. And I didn't address that here in the PowerPoint, but it is possible to access multiple systems at the same time. There may sometimes be good reasons for that. There may be reasons why that's not the best idea, but it is possible. So if we have a state complaint that has the same issues as a due process hearing, by regulation, we have to put that complaint, the term is in abeyance. Basically, we put it on hold until the due process hearing is resolved. But if there are different issues, the due process is about the student's special education placement, and the complaint is about, the student didn't receive, accommodations, they both could be going at the same time. Other questions? All right, so we,
I have a question.
okay.
So, I've seen a lot of parents, either have, when we facilitate an IEP meeting, they might have, an agreement, right? Or from a state complaint, they have feedback from you guys with directions. So, for example, on a state complaint, when the parent gets the feedback from the state, I guess my question is that a recommendation or is it mandatory? Because I've seen schools not actually follow the state complaint recommendations that you guys sent back.
So, it sort of depends on how it's worded, but so if we identify one or more violations, we are requiring corrective action. So if we require corrective action, that's not optional.
Okay.
It's mandatory, and the investigator who issued that decision monitors, so the district would have to provide at some point information to us to show that they've complied with that order or that ruling. So the investigator monitors that. There are some situations, sometimes in which the investigator may not identify a specific violation, but may suggest or advise that the district does something, which that would be advisory, so that would be optional. So that's a little bit different.
If the family, if they were the things that had to be monitored, and if they weren't happening, then what step does that parent take?
So they could contact the investigator that's assigned about that. So we would, so that's, again, that's one of those issues where we may say, does the district know about this? So we have to contact the district. We were supposed to have an IEP meeting within a month, and we haven't had it yet. So again, that may be a little bit quicker way to resolve it, but it would be either contact the district and say, hey, this is what the order showed, and this is not being done. If that's not successful, then they should contact the investigator. Okay, so we've got about 5 or so minutes left, so I did want to talk about, so what's the right option, right? Okay, so we offer 4 different options. There's also the local level. What's the right one? And that's not something that I or we at ISB can really tell a parent, well, this is the right option in this situation. There's a number of factors that play into it. But I did want to include some questions to think about, to consider, if you're a parent and in that situation, such as, what's the issue I'm most concerned about? So there are some issues that kind of lend themselves a little bit better to certain systems. If you just feel like, I don't think my child's IEP is currently meeting their needs, we need a new IEP. Well, that kind of probably directs you towards IEP facilitation, if you really think that's what the child needs. If you believe that you have a disagreement about the child's placement or program, I feel like my child has been in a therapeutic day school, but I think he can come back to the district and be successful in the district, and the district disagrees. That's a placement issue that may be a little bit better suited for mediation, maybe a due process hearing. If you have an issue where I just had an ongoing issue with the district, I don't think they're doing this right, whatever this practice is, I just need somebody to come in and tell them that they're not doing this practice right, okay? That may be a state complaint where we could look at the regulatory requirements, tell the district if they're not doing something correctly, and then require corrective action, maybe require training. As I mentioned, how quickly would I like this concern resolved? You go to due process, that may take a while. State complaints, a couple of months. Mediation or facilitation, a month, 2 to 4 weeks, okay? Am I still able to work with the district to resolve this concern? There are some parents that talk to us, that we hear from, that are so frustrated because of, years of maybe dealing with the same people at the district, not feeling that their concerns are heard, that they are just kind of done at this point of trying to communicate with the district. If that's the case, then you're probably looking at maybe a state complaint where there's not going to be any face-to-face between the district and the parent in the state complaint. The investigator is going to contact everybody separately and try to determine what's going on, whether the district has violated the child's rights. If you feel like you can still work somewhat collaboratively with the district, that's maybe IEP facilitation or mediation, okay? I can still sit down at a table in a room with the principal, with the special ed director, maybe with somebody's help, a mediator, and try to resolve the issue. So those are just a couple of quick things to think about in terms of what the right option may be in a certain situation. I provided some links to some resources that can help parents in making that decision. We have a comparison chart that we have developed that kind of outlines in a little bit more detail the 4 options that we offer. That was actually adapted from the resource below, which is an organization called Cadre, which is a federal technical assistance center located out of Oregon. They work with many states, including our own, on dispute resolution. They have a very good comparison chart and a ton more resources as well that are great for parents about communicating with school districts, about all of the different dispute resolution options. So I highly, highly encourage, if you have an interest in this topic or have working with a parent that would, to kind of connect them to that Cadre website. And then we also have our parent guide for special education, which is available on our website, that goes in pretty good detail into really all the elements of the IEP process, including a chapter on, it's called conflict resolution, but again, it's dispute resolution as part of that guide. A couple other real quick options. Again, these are not special education dispute resolution options per se, but I thought they may have some relevance to this audience. Our agency does have a multilingual complaint process, and then the U.S. Department of Education's Office for Civil Rights has also a complaint process where investigations of 504 issues could be addressed. And then finally, just a couple more additional resources on our parent training and information centers that we have in the state, and then some more information from our agency, cadre, and the U.S. Department of Education. Okay. Oh, I'm right on time. Any last questions? I have my contact information there. If you have questions, additional information that you need from us, you can contact me directly, or we have other staff as well that can address any questions, concerns related to dispute resolution options or special education in general. All right. Thank you very much for your time. Hope you all enjoy the rest of the weekend. You're welcome. Yes, it's nice to have spring weather, isn't it?